Hi guys, welcome back to Battle with Ola. This is Mujola Olua. Today we want to quickly talk about the two types of legal systems that are used the world over. The two types of legal systems that are used the world over are the adversarial system and the inquisitorial system. The adversarial system and the inquisitorial system. The inquisitorial system is mostly used in Europe in countries like Italy, France, and so on, while the adversarial system is used in England. So basically, all countries that were colonized by England used the adversarial system. In modern times, some may have made some adjustments to it, but generally, the adversarial system is used in England and by countries that were colonized by England who adopted the English legal system. Countries like Nigeria, for instance, will use the adversarial system. The United States of America also uses the adversarial system, while European countries use the inquisitorial system. What are the major differences between these types of legal systems? Let's start with let's compare and contrast for ease of understanding. Please subscribe to the channel and don't forget to share the video. As the name may imply, the inquisitorial system involves inquisition, and that is mostly done by the judge. So the judge is allowed to descend into the arena technically to inquire into facts and evidence and to substantiate issues. So the way it works is that the judge conducts a preliminary investigation before the case goes to trial. So it is the preliminary investigation in most cases that will determine if the case will go to trial or not. So during that investigation, the judge will make findings, make discoveries, look for, try to gather evidence to piece together evidence to see if there's a case that needs to go to trial, a case that the defendant needs to answer if it's a criminal matter, and if it's a civil matter to see if there's a substantial case to be adjudicated upon. So he would make inquiries, ask questions, demand for some pieces of evidence, and then decide if the case will go to trial or not. Also, during trial, the judge is allowed to descend into the arena to ask witnesses questions directly to fact find, basically, to arrive at the truth. So, but for the adversarial system, parties stand pitched against the other, to prove their case before an unbiased umpire, that is the judge. So the judge is basically like an umpire, just presiding. So he would decide based on what the parties can prove before it and give judgment to who can prove their case. So he's less concerned about helping them to discover facts or to discover documents or to bring evidence. He basically waits or stands aloof for them to bring their evidence to prove what they are claiming before the court or what they are accusing the other person of, and then he will make his decision. So this both cases could involve the jury or not. In Nigeria, we don't use the jury system, so it's basically the judge. So the adversarial system in Nigeria is basically in a criminal matter, that of the state or the prosecution filing a charge before the court, and then the defendant coming to court to defend himself against that charge. So the prosecution's duty is to prove that charge with a plethora of evidence, oral evidence, documentary evidence, to prove that charge. And then the defense comes to pull apart the case of the prosecution and to prove the innocence of his client, that if he's represented, which is the norm. So that's for a criminal matter. And then the court will decide on the weight of the evidence. If the prosecution is able to prove beyond reasonable doubt, the court will decide for the prosecution. But if they are not able to prove their case, the court will decide for the defendant. The mantra is that it is better to let 99 guilty persons go free than to condemn one innocent person. So if it's also a civil matter, parties will come to court. One will bring a claim before the court. The other will come to defend the claim or bring a counter claim. So both parties need to source for their own evidence, bring it before the court. The court will then decide. They call their own witnesses, the court will then decide on a preponderance of evidence, that is on a balance of probabilities, whose case, that is on a balance of probabilities, whose case is more likely to be the truth, whose case is more likely to be plausible, the court will then decide. So the judge in Nigeria, in the adversarial system, is an unbiased umpire. He is not allowed to descend into the arena. In fact, if the judge descends into the arena, it could be petitioned for bias, and it could be also a ground for appeal if the bias is so manifest and so undoubtedly done such that it prejudices the case of one of the parties. The party can appeal on that basis. So that is what the adversarial system is. It's basically the law saying that we're not going to help you. If you want us to do anything for you, come and prove to us why we should do it for you. But in the inquisitorial system, the law assists the parties, to reach the truth. So essentially, for the inquisitorial system, the goal is to reach the truth, to arrive at the truth. But for the adversarial system, it is to do substantial justice, that is, to arrive at what is plausible. In some cases, it may not be the truth, but the court will work with the evidence that is before it. So it will work with facts. So it is to do justice on the basis of plausible facts, not necessarily to arrive at the truth. So these are the kinds of systems that are run all over the world with slight modifications here and there. So I hope you understand. Let's go over the major differences and similarities so that you can get it. Let's talk about the role of the judge. In both cases, the role of the judge is the easiest way for you to determine the difference. In the inquisitorial system, the judge descends into the arena. So he asks questions, he facts find. So the judge descends into the arena, he asks questions, he fact finds to arrive at the truth. So he's basically helping the parties arrive at the truth. So he will make his own findings, he will put his own questions to the witnesses, to the parties. He could even draw up issues outside of the issues that parties have come to court with, issues that are necessary and antecedental to the matter. He could draw up those issues to be adjudicated upon. So, but in the adversarial system, the judge is an unbiased umpire. He stands aloof, he sits over, he presides over the matter, and then parties need to prove their own cases before the court by bringing their own evidence, their own witness, posing their own questions, going through the trial process, examining and cross-examining witnesses, and then the judge will make a decision on that basis. So the judge does not have the latitude to descend into the arena, to formulate issues outside of the issues parties have brought to court, or to go on a fact-finding mission on behalf of any of the parties in the adversarial system. But in the inquisitorial system, the judge can't do that. That is one. The second one is evidence gathering. In the inquisitorial system, the judge also gathers evidence as well as the parties. So essentially, it is teamwork. The judge joins the parties to pull together evidence in support of or against, the case and the issues, so that they can arrive at the truth. But in the adversarial system, parties need to gather their own evidence. The judge will not help them. That is why often in Nigeria, the judge will tell you that the court is not a Father Christmas. The court will not grant what you have not asked. They will not help you to go look for judgment. So even if sometimes some facts or some documents, some pieces of news or evidence are things that are known to the judge himself, or that are within the judge's reach, the judge will not help you to get them or put them in the case if you have not done that by yourself, because he does not have the latitude to do that. I was in a case, and the judge had granted an injunction, an interlocutory injunction for parties to stay all activities on a piece of land while the matter is going on. So one party came to court the next day, adjourned date, and was telling the court that the other party had gone on the land, that they had done so and so on the land, that it was even public knowledge, it was in the news, everybody knew that they were doing that on the land. The judge said, "What do you think the court is? If it's in the news, it's not before me. You should have brought that piece of evidence in support, maybe the newspaper, the news report. You should have filed it before the court so that we will see it. But if you don't place it before me, you can't come here and tell me it's in the news expecting me to know." Even though the judge is a member of the society who would probably already have heard or read or watched the news, he will not act on it because it is not before him. So evidence gathering, the burden is on the parties in the adversarial system, but it is on the judge and the parties, a joint effort in the inquisitorial system. The other thing to consider is the trial process. For the inquisitorial system, the trial is less formal and less structured. So once the trial starts, if the case goes to trial, the judge is very involved. He can ask questions, and he can fact find even during trial. And the trial goes on, until they finish. So it goes on and on and on and on. It's not really structured such that you come to court today for this, come to court today for that. So the trial just goes, there's a free flow. So it usually continues until it comes to an end. So it is not structured into segments, so to speak. But for the adversarial system, the trial is very formal, very structured. And the judge does not descend into the arena during trial. So it is structured in the sense that you could come to court today for pre-trial conference or case management conference, which we've talked about on the channel. Please look for the video and watch. That's in a civil matter. You could come to court today for mentioning the case in a criminal matter or a civil matter. Then you come tomorrow for trial. Then you come the next day to adopt written address. You come the next day for judgment. You could come for several things or separate things on different dates. So it is more structured and broken into segments, but not so in the inquisitorial system. The trial process is free-flowing and less structured, less formal in the inquisitorial system. Also, the trial is very much judge-controlled in the inquisitorial system, while it is very much counsel-controlled or attorney-controlled in the adversarial system. So the lawyers, the representatives, the legal representatives of parties have more latitude, have more control in the adversarial system. They are basically in charge of their own cases, until they close their case, and then the judge has to make a decision. But in the inquisitorial system, the judge is highly in control of the case. So the case could basically rise and fall on the judge. Also in the inquisitorial system, the decision is made by the judge, the final decision, while in the adversarial system, it could be made by the jury or by the judge. So those are the most important differences. So, but the way to easily remember it is inquisitorial. That's to inquire, from the root word inquire, that is to fact find. So you would easily remember. But adversarial, that's an adversary, an enemy. So parties are opposed to each other. So it's let the best man win kind of situation in the adversarial system, which is what we are practicing in Nigeria and in most countries that have adopted the English common law system. In most common law countries, they use the So that is what we use in Nigeria and in most common law countries that have adopted the English legal system, because that is what is practiced in England. Additionally, in the inquisitorial system, the lawyers or the counsel are trying to assist the judge to arrive at the truth. The judge is also trying to assist the parties to arrive at the truth. But in the adversarial system, each man for himself. The judge is on his own, waiting for you to close your case so you can make a decision on what is before him. And each party is trying to prove their own case to the detriment of the other party or against the other party. So I hope you understand it. That's all I have for you in this video. Don't forget to like, to subscribe, and to leave comments in the comment section. If you have any inquiries, any questions, leave them in the comment section, or send a mail to houseoflivingstones@gmail.com. And if you have a personal challenge, legal challenge that requires tailored legal solution, you can book a consultation slot with the link in the description box. I will see you in my very next video. Don't forget to subscribe to those.